Well, good afternoon, everyone, and welcome. I'm Pat Parody, the Executive Director of the Center for Constitutional Studies in the Faculty of Law at the University of Alberta, and I'm pleased to introduce today's webinar. Before I do, I want to encourage you to think about the land that you inhabit. Our center, the Center for Constitutional Studies, is on Treaty 6 territory, and we honor the ancestors, traditions, and the spirit that first drew Indigenous people, the Cree, Blackfoot, Nakota Sioux, Iroquois, Dene, Saulteaux, Inuit, Métis, and then settlers to this gathering place. And we are grateful for the many benefits we've received as a result of the treaty signed in 1876. We also recognize the ongoing acts of settlement and colonization that take place here, and that honoring this land and its ancestors is only a very small step in recognizing the spirit and intent of Treaty 6 and of our efforts toward reconciliation. Now, today's webinar, Animals as Legal Beings, Contesting Anthropocentric Legal Orders, is part of a Reimagining Rivers series, which is being organized by the Center for Constitutional Studies and the Environmental Law Center in Edmonton. The series is designed to help us rethink and reimagine our relationship with the environment. And to date, we've hosted webinars on rivers as legal persons with rights, Indigenous jurisdiction and the environment, where Cree Indigenous laws and Haida Indigenous laws were presented. And by the way, those are available on our website as recorded YouTube videos. Today's webinar, which will also be recorded, will examine and challenge the ways in which we view animals as legal beings. Now, I'm very pleased to introduce our two speakers, Professors Maneesha Deckha and Jessica Eisen. Maneesha Deckha is a professor the Lansdowne Chair in Law at the University of Victoria's Faculty of Law. She received her BA from McGill University, LLB from the University of Toronto, and her LLM from Columbia. She has been with the Faculty of Law at UVic since 2002, where she teaches animals, culture in the law, feminist legal theories, and health law. And her research interests include animal legal studies, critical animal studies, and feminist animal care theory. Now, Professor Deckha's work has been published in numerous academic journals in law as well as in other disciplines, and she has been featured in non-academic spaces such as the Museum of Modern Art in New York and CBC Radio 1. She's recently published her book, Animals as Legal Beings, which we're going to hear about today, and a book chapter titled Constitutional Protections for Animals, a Comparative Animal-Centered and Post-Colonial Reading. That was in Anti-Colonial Perspectives on Animal Studies, published in 2020. Now, Maneesha has received the University of Victoria's Faculty of Law Terry J. Wooster Teaching Award and a University of Victoria Learning and Teaching Center grant. Professor Eisen is Assistant Professor in the Faculty of Law at the University of Alberta, where she teaches foundations of law, constitutional law, and jurisprudence. She has studied at Barnard College, Columbia University, where she received her BA in Political Science and Human Rights Studies, the University of Toronto Faculty of Law, her Osgoode Hall Law School, where she received her LLM, and Harvard Law School, where she received her SJD in 2019. She also worked at Weir Fowles LLP, the Ontario Ministry of Labour, and the Constitutional Law Branch of the Ministry of the Attorney General for Ontario. Now, Professor Eisen's research interests include animals in the law, constitutional and comparative constitutional law, and equality and anti-discrimination law. Her research has been published in numerous law journals, including the Journal of Law and Equality, Animal Law Review, Canadian Journal of Poverty Law, Transnational Legal Theory, just to name a few. She has most recently published Milked, Nature, Necessity, and American Law in the Berkeley Journal of Gender Law and Justice, Feminist Jurisprudence for Farmed animals, I should say, in the Canadian Journal of Comparative Contemporary Law, and Animals in the Contemporary Constitutional State in ICON, the International Journal of Constitutional Law. Now, just to describe to you how we're going to proceed today, Professors Eisen and Deckha will engage in a discussion, and Jessica will primarily be asking Maneesha questions. And after they've concluded their discussion, they will respond to questions from you, our audience. And just to remind you, you can use the Q&A button at the bottom of your screen to ask questions throughout the presentation as well as afterwards. The chat function has been disabled. And remember that if you see a question you like in the Q&A stream, you can what we call upvote the question by clicking on the little thumbs up symbol, which you'll see next to the question. And as you no doubt know, we would likely will not be able to answer all your questions, but we will deal with as many as possible in the time we have today. So without further ado, over to you, Jessica and Maneesha.
Thank you so much for that generous introduction, Pat. Thank you for setting this up and situating us in the Reimagining Rivers series. So for those of you who've been following along in this series, you already know that this series on Reimagining Rivers is partly inspired by some grants of legal personhood that have for rivers that have occurred in Canada and other jurisdictions, often inspired by the continued vitality of Indigenous legal orders within settler states. And the overarching theme of this series has been self-described as, quote, rethinking and reframing relationships with the environment. So our focus today is going to be on non-human animals. What is the status of non-human animals at law, and what should it be? So for those of you who are not scholars of animal law, you may already know or not that in Canada, as elsewhere, animals are presently categorized under legal authority as property. And this property status of animals has been associated with instrumentalization of animals, exploitation of animals, and the keeping of animals in situations that are harmful to their immediate interests. For this reason, a lot of litigation and scholarship in the field of animal law has focused on getting animals out of this category of property. And for many years, the focus of these efforts of getting animals out of the property category has been on getting them into the category of legal persons, or in some cases, moral personhood as a route to legal personhood. Professor Deckha has written a new book, Animals as Legal Beings, Contesting Anthropocentric Legal Orders, which has broken the mold on this conversation. Professor Deckha brings forward critiques of property status and builds upon them, but also layers in a critique of personhood as the goal to which so much animal advocacy and scholarship has aimed. In short, Professor Deckha identifies personhood as a relic of an overly individualistic, rationalist liberal legalism, which he describes in short as, quote, not an animal-friendly category. Instead, Professor Deckha puts forward the idea of beingness, that we might consider animals to be legal beings, a category different from property, as protective as personhood, but also entailing an ontological shift towards attention to vulnerability, relationality, and embodiment. So we're going to start our conversation today with me leading Professor Deckha through some of the main arguments that are put forward in this groundbreaking text. And then I have a series of questions that I want to ask Professor Deckha based on my reading and rereading of this book. And I think it's important to say, for those who are outside of the direct field of animal law, just how important and conversation shifting this work has been. I refer to myself as reading and rereading this book, and I think that it's certainly the case that everyone within the field of animal law is going to be reading and rereading this book for years to come. So I'm going to start with the questions that have been prompted for me as I read through this text, but I'm also going to be managing the Q&A. So if, as Professor Deckha is speaking, things occur to you that you would like to see acknowledged or addressed, please drop that into the Q&A. And insofar as I'm able to, I'll work them into the conversation. But I assure you that even if your question does not end up being addressed directly in this webinar, that I will pass your thoughts along to Professor Deckha so that she can consider them as she develops her research in this area. So With that, I'm going to get started with just some basic questions to help us get a sense, Professor Deckha, of what you've laid out in this book. So, if you could start off by giving us just a summary of what, in your view, the problem is with treating animals as property. Why can't we just improve animals' situation within the property paradigm that currently exists?
Thank you so much, Jess. Yes, thank you for your very generous comments. And I'd also just like to preface my answer with acknowledging with respect the Lekwungen peoples on whose traditional territories my university, University of Victoria, resides, and the Sanghees, Esquimalt, and Wasanich peoples whose relationships with the land today remain profound. So yeah, that, this territorial acknowledgement and the depth with which it was introduced for where you're located by Pat, really does relate to this question of property. What's wrong with propertizing animals, with commodifying animals? So if we unpack property as a legal status, we understand that it's a very subordinating legal category. It expresses a social relationship of domination, commodification, objectification, and just basically all around exploitation. It allows those who have rights in what the law classifies as property to instrumentalize that entity as they wish, just subject to certain regulations that might be in place that the government thinks might, streamline an industry or make it more functional or hold it to some standards of functioning. And by and large, when we think of all the animal use industries that we have, and some are, so invisible to us, animals function here as property, and they're in an exploited status. So if we want to think of animals as something other than resources for humans, as something other than inferior to humans, as deserving of a much higher moral status, then the legal status also needs to reflect that. So that's why kind of I reject property quite foundationally.
So for those of us who are persuaded that there is this sort of fundamental defect in property status as a way of advancing the interests of animals, why is personhood not a viable alternative? Personhood is the legal status given to human beings that ostensibly grants them rights. Why is it that framework that so many advocates have been pursuing seems inadequate in your view?
Yes. So, but just to lay out, right, like in the common law, we might think that, yeah, personhood is like the corrective. And I think one of the reasons that animal law scholars have gravitated so much to personhood is because we are existing in a binary system that presents us with these two options, such polar opposites. And we know that non-humans can come under personhood's kind of purview and have for actually centuries. Here I'm talking about corporations, which are not, even a being that has a shape or a form, right? Is completely like a distant and alien entity to what we think of as humans. So it seems that personhood can be amenable to non-humans. So why do I argue that it's not? Well, for several reasons. So one of these reasons is that despite the non-stable nature of personhood, so I don't want to suggest that personhood, when we look at legal texts like decisions from courts or legislative texts, so coming out of legislatures, that personhood has a singular unified meaning across all jurisdictions, right? That's not the case. Even colonial jurisdictions or those that are shaped by the common law, as ours is, as well as the civil law. But what personhood scholars looking at, taking a deeper dive into common law jurisdictions, looking at how legal actors, judges primarily, but also others, operationalize this term, certain things we can note from that study. One, that first of all, this foundational legal concept is rarely defined. It's just presumed to have a meaning, and that meaning varies. And second, the topology that can be identified, and this is Nagar Nafeen's work that I'm drawing on, I rely on heavily in the book, is one where personhood, typically corresponds with this kind of biological identity of the human. So it's like a sacred, very much a Judeo-Christian ethic of all humans are, or all human life is sacred, and all humans are persons. The other is kind of an empty vessel type of conceptualization of personhood that allows corporations to get under the label. It doesn't have any content until a judge said, oh yes, this is a person, right? So, but third is the kind of rationalist version of personhood. This is the version of personhood that is tethered to not just humanity and humans, but a certain type of human, what I and others call a paradigmatic type of human, or kind of, a self-maximizing, disembodied individual, rational actor who organizes their affairs according to like economic calculus of what's in their best interests. And even though there are fluctuating and competing versions of personhood available, the argument that personhood scholars have advanced is that this third one, the rationalist version, is very influential, even when the other two versions are being assumed in a particular legal judgment. So even if what's at issue legally is corporate rights and the rights of corporations, which we know are persons under the empty vessel conceptualization of personhood. Reasoning about what rights corporations may have also tethers back to the human rationalist actor, right? So this, again, disembodied, autonomous, reason maximizing actor, a person that's defined by the capacity to reason. And so for this reason, kind of the gravitation of all concepts of personhood back to this rational actor, so which you can see even in corporate rights cases, as well as the fact, I'm drawing on some other scholarship, that we could trace the personhood property paradigm to really kind of being scaffolded by a human animal paradigm, such that the concept of legal personhood emerges out of a vision of humanity that's distinguished against animality. So for these two prime reasons, I suggest that, it's not simply the case that personhood started off historically as a very exclusionary concept, and then, we extended it out to all humans, and now we can just keep extending it out to non-humans, right? That kind of vision, that extensionist vision of personhood, I argue is like impoverished by failing to account for the fact that personhood as a concept rests on the backs of animals. And so it is kind of given shape by an objection of animals. So that's why I say it is not an animal-friendly category. Now, is it better than property? Yes, right? Of course. But can we do better? I do think we can. And it's not what I would call like a high-risk situation, because we're, in terms of trying to get other legal actors to be persuaded by what I'm saying, because we're operating in Canadian law in a landscape where it's very difficult to persuade legal actors that animals matter, that we should not be anthropocentric, that we need to think kind of relationally about multi-species communities. That's still very much a foreign argument. And in legal circles, the idea that all animals should be persons is very much a foreign argument. As Nafeen and others noted, this is a laughable argument for most, right? It's still ridiculed in these colonial legal orders. So if we're at this space, of trying to, and personhood is still a lofty aspirational goal, my view is let's try for something else. If we're kind of this preliminary starting point of trying to get animals out of the property category, why go with something that is steeped in liberal humanist benchmarks?
Wonderful. So, in this vein of we can do better, that, maybe personhood is better than property, but we can do better, as you said in your answer, you propose beingness as this alternative category that embraces not just a new legal status, but also a whole shift in ontological assumptions of the legal order. So I was hoping that for those who haven't yet had the opportunity to read your book, that you could share a little bit about this new legal status and its associated ontological shift that might help us to do better than personhood as the alternative to property.
Sure. Yes. Thanks, Jess. Okay. So if we think of the constitutive factors of that rationalist iteration of personhood as being, so we can, another way to say that, who is law's reasonable person, for example, when we say person, what type of being are we normally thinking about? What picture comes into our mind when you hear the word person in law? Okay, so this would be a disembodied person, a disembodied individual. So we don't know really anything about their social location or identity investments, right? Or kind of positioning in social hierarchies, whether with respect to gender, ability, or class, race, what have you. They're just disembodied. We don't even talk like much about their body. Okay, they're also imagined to be independent and autonomous, right? So, and their autonomy is seen not to be relationally connected, but just independent. So they're existing as a unit, and there's no one else around them. Even though, right, like we understand that none of us come into this world like this, and most of us don't exist in the world like that in our lifespan or leave this world like that. Okay, and then of course it's that rational actor. Why is it that humans get to have this privileged status in law? Right, within the first sentence, you will hear something about reason, that humans can reason. Even, of course, we know that there are exceptions to this, again, at this beginning of life, in terms of the standard that the law expects when we say humans can reason, or for some of us, right, throughout our life, or closer to the end of our lives, what have you. The fact that not all humans reason to a certain level all the time, that's irrelevant. The paradigmatic human actor is someone who can, attain the status at some point, or is reaching for the status. Okay, so on each of these three kind of attributes, a legal being, so beingness as juxtaposed against personhood, would replace the disembodied feature with an embodied feature. So we would look to embodiment. Is meant to replace the kind of independently autonomous person with a relational vision of a being. So someone nested in a family or a community, certain networks, at least ecological networks. And as opposed to valuing the capacity to reason and exalting the rational actor, legal beingness would value the capacity to be vulnerable, right? And then so kind of spotlighting the vulnerability to which our capacity or animals' capacity for embodiment and relationality give rise. So to the extent animals are embodied, they're at risk of having that embodiment interfered with, right? Either psychologically or physically. And so sentience is a important value here in thinking about who animals are. But as I hopefully made clear in the book, sentience is not a necessary condition for beingness. And relationality, we have animals that are in families and networks, and they're always at loss when they're used in animal industries to being taken out of the sources of value for them. That's what makes the vulnerability, very much in the same way that humans are vulnerable to these losses if people interfere with our lives. So that's how, so then, if we have a legal system that classified as legal beings, what would that mean? It means that we would think about animals as embodied, relational, and vulnerable beings and be responsive to that vulnerability, rather than trying to maximize the actions and flourishing of those that we see to be rational, self-maximizing autonomous actors.
Thank you for that. So I think that that there's an objection that you anticipate within your book that I want to give you a chance to speak to here. So you set out in the book that this new status is not something less than personhood. It includes everything that personhood includes. So your concluding chapter really sets out this kind of vision of a world informed by this shift to beingness, where we see the shuttering of all animal use industries and a completely different kind of relationship with non-human animals emerging. So I think that there are people who have long advocated for personhood status who would say that was their vision. They wanted to see all these animal use industries shuttered, and that maybe there is no material difference between what you're calling for and what personhood advocates have been seeking. So what would you say to the objection that your program is just sort of personhood by another name?
Yes, Jess. Thank you for this and all the other questions. So yeah, I mean, I would partly agree. Like it is not it is not a concept that's aimed at a different outcome than what personhood scholars in animal law circles have looked for, which is, as you say, an abolition of animal use industries. But it is a concept that creates kind of different arguments as to why we should aim for that type of abolition. And I do think it materially makes a difference as to which animals will kind of receive attention first and for how long or if ever. So many of us here may have heard about kind of groundbreaking litigation campaigns based on personhood in the United States or in other jurisdictions. For example, there is the Non-Human Rights Project in the United States led by attorney Stephen Wise, who's also taught animal law at Harvard for many years and has spent decades doing, really grounded empirical work trying to figure out which kind of judicial county would be the most strategically viable county to bring like a personhood action to persuade a judge to recognize the legal personhood of animals. And we have seen in recent years these lawsuits go forward, and we've also seen these lawsuits in other jurisdictions, and invariably the animals who are kind of the litigants or the proxy litigants, right, on whose behalf the human parties come forward, are in their cultural milieu humanized animals. And we can immediately understand that. You're trying to convince an otherwise anthropocentric judge and legal system to recognize animals as other than property. You're going to want to start with your best type of, person candidate, which is not going to be the animals that are despised in a certain culture, or that the ones that as Matthew Liebman has said in an article titled "Ate for Breakfast That Morning." Yeah. So, and I don't want to diminish at all those campaigns, right? And I even, like, in different respects, have contributed my support to those types of campaigns. And I don't for a minute want to diminish the suffering of the humanized animals in their spaces of captivity. At the same time, I also don't want us to normalize legal arguments that, because we know in many legal systems, like the common law, this forms precedent, right? The arguments get converted, if persuasive to courts, into legal reasons supporting a decision, and then that goes forward for years or decades to constrict the law. And if we argue for animals through personhood, you will see a trend of talking about how these animals are similar to humans. So it's setting up the human benchmark and saying, this animal meets it. Okay, and again, I can understand that as legal strategy. But what about all the animals who are never going to meet that human benchmark? right? And so, and here we can even think of the mammals. We don't even have to think about like insects. Like, what about all of the animals in the farm system, right? That are, and if we think of the numbers of the animals in animal use industries, like, I mean, this is where it is at. So how are they going to benefit from those personhood types of claims is not at all clear to me. So beingness versus personhood, doesn't talk about, for example, the autonomy of this animal and how they can reason just like humans, or that they're shown to be cognitively intelligent to X level. Rather, it would talk about the kind of embodied relationality of these animals that make them vulnerable, that what happens to them when they're taken from their families, the loss or grief or mourning that animals experience when their children are taken away, for example. So, I'm willing to concede it's a subtle difference, but I think subtle differences can still be important in how we talk about things and create discourse or stories about why animals matter. So the outcome, yes, I think it's easy to, yes, I would concede is the same. Let's stop this violence against animals that is so normalized. But the pathway and the why of let's stop it is, I would say, considerably different.
Thank you. That's really helpful. And I think that this dovetails with a question that I'm seeing come in through the Q&A here. An audience member is objecting, or maybe objecting is putting it too strongly, is noting that that animals do reason. So maybe, a legal standard like personhood that seems to embrace this idea of rationality, could be applied in a way that is found favorably for animals. But what I'm hearing you say is that it's not that animals will inevitably fail, or that all animals will inevitably fail on the rationality standard, but that the rationality standard doesn't capture everything that we would want to capture about why it's important for law to care about animals and how. But I wanted to give you a chance to ask if there's anything you want to layer on in terms of kind of this thought that, well, if animals do exhibit rationality, why we wouldn't want to just keep working with that framework.
Yes, thank you. Well, I mean, here I would also draw from the scholarship in feminist theory, critical disability theory as well. Like, when we say X being matters, we are asking the question, why? Right? And do we really want to be a society that says only a being that can reason matters, or reason to a certain level? Right? And right away, even if we're just thinking of humans, we're already in a position of contradiction when we think of human babies, right? I'm sure there are outlier babies, but I think the evidence establishes, right, that at least in year one, what we think of as reason is something that comes a little bit later in typical development. And then what about atypical development then for human beings, right? And so do we really want to say that someone only matters because they reason? And then we look beyond the human, and right, this series is kind of constituted by rivers. I mean, why is it that a river has to reason before we're going to say that it's important? So I certainly take the point, and I think perhaps it's coming from, the concern that I have as well, that we don't even see how animals reason, right? We say they're not intelligent when actually they are, right? And yeah, and that is important to know as well. But I don't want to make that the standard as to who gets legal protection. I don't think that is a world based on empathy and compassion and responsiveness to vulnerability. See that as entrenching the same kind of humanist benchmarks that are, ultimately exclusionary, because not everyone that we may wish to matter for reasons other than reason are going to be able to reason.
Yeah. Wonderful. So, I have a question here that I think relates to kind of the chasm between where we are now and where your proposal would put us. I have a question here in the Q&A pointing out the really thoroughgoing normalization of animal exploitation in society right now, and how intimately connected that is with property status. And so I want to put to you, this status quo reliance on animal products in so many sectors of society, and the deep imbrication of those use practices with property as a legal category. This is a major kind of a major shift, to put it mildly, that you're calling for. And I was wondering how you would respond to the suggestion that these use practices and legal apparatuses are really deeply entrenched, and what would it look like to actually see the kind of change that you're calling for in the face of those use practices?
Yes, no, I mean, definitely. Yeah. What I'm calling for is a radical shift in society, a completely transformative shift. Indeed. Uh, we rely on animals in almost every use throughout our day, right? In ways we're not even aware. So yes, I'm not, naive to think this is going to happen tomorrow. At the same time, we have seen some things in recent years. We have kind of seen, not 180 turns, but considerable shifts in our kind of national awareness about certain issues. Um, Whether we can think of reconciliation for Indigenous peoples, and just the idea of Indigenous legal orders as being a concept that makes sense, right, to more and more people. Whether we think of, disrupting our so entrenched notion of gender as a binary coming from Judeo-Christian thought. And there will be other examples, even how we think of people with varying levels of ability, and what is a disability and what is an ability. We have also seen, right, with our pandemic, and we can talk about the animal use reasons for why we're in this pandemic. A quick pivot from governments when they had to, right? So when there was perceived to be a desperate need to move differently in the world, that did happen. Perhaps, and of course, there's critiques that some governments didn't move very quickly at all. But if we just take our Canadian situation, we saw quite radical things happening that we haven't seen before, and quickly, right? In terms of social disruption and social engineering. So it is, right, the book is primarily, an academic text that is setting out an argument that hopefully will be persuasive to not just academic audiences, but members of the public. It will have traction in policy circles and legal circles the more these ideas come into the public sphere. And again, right, so if you take the alternative being personhood, we're in a similar space of aspirational reaching for that concept. So I think it's important that I'm not trying to say, let's claw back all the progress on personhood and start something else for animals, because I don't see, right, at all any progress for animals on personhood. There's some cases, and we can talk about that more, but they're very qualified in what they provide for animals.
So I think this gives us a helpful bridge to my next question. So we're looking at these sort of grand efforts at transformation, and I think something that's really interesting about your work that really distinguishes it from I think anything else I can think of in the field of animal law is that you don't limit your theorization to animals specifically. That in fact your concept of beingness talks about transformed relations for a bunch of different, what are sometimes referred to in the literature as natural objects, not my favorite term, but natural entities, we might say. So, you talk specifically about plants, rivers, and oceans as entities that might be call for transformed legal approaches, but not all of them through this vehicle of beingness. So I wanted to invite you to say a bit more about these diverse kinds of natural entities and why you've decided that some of them are good candidates for this idea of beingness, and what kinds of transformations outside of the beingness framework might you envision for entities that you think are deserving of respect, but not quite a good fit for the model you're setting out here?
Sure. Yes. So I'll just start off by saying like that. So that discussion is largely housed in one chapter of the book, and that chapter was, at the on one side, kind of the most, terrifying to write, and also the most interesting and invigorating to write, because I felt like this was a very under theorized area in academic discussion about animals. And again, we can understand why, because the focus has been so much on getting people to care about animals, that thinking about, whether the way I'm kind of suggesting why animals matter, like what kinds of exclusions might it be in initiating for other non-humans, which is not something, I wanted to do. So plants feature a lot in this chapter to think about, what is it that human beings owe to plants, and is beingness a appropriate category for them. And so kind of where I come down in thinking about these other non-human entities is basically to say the following, because so as some of us may be aware, like in animal law circles, there is a concern that um, any type of legal protection for animals gets watered down into what Gary Francione has influentially called a legal welfare system. So if you think right of anti-cruelty statutes or even endangered species legislation, these are perhaps perceived by many of us in the public to be protective statutes for animals. Here's one space, and otherwise, if we accept the argument that Canadian law is otherwise anthropocentric, here's a long-standing area of legal regulation, anti-cruelty statutes through the criminal code or otherwise, where animal interests are put first. And so Professor Francione's work in the American context is to completely dispel that argument, and I have taken that work up in the Canadian context. And the critique there is that when animals are property, any type of kind of protective measure you might put in a for one area of life, i.e., you can't be cruel to animals. That's written down in legislation, like an anti-cruelty statute, and then a dispute arises and someone has to interpret what does cruelty mean. As we have in our Canadian jurisprudence, it gets tethered back to anthropocentric worldviews about who's on top and who's on bottom, right? And that's how we define cruelty. And in fact, we know what goes on in the factory farms. We know what goes on in the biomedical labs. And that's not seen as cruel, because cruelty always had a different, very tepid, limited register. Okay, so when writing about beingness, I did not want the status to be kind of accused of legal welfarism. I don't want it to be a status applied to any beings that is not as protective as personhood. So why is personhood seen to be protective? I mean, if you just think of our own personhood status, what does that do for us in the law, or what is it supposed to do, even if materially the law is not being enforced properly? It's supposed to be a full stop against instrumentalization that you do not want, right? So no one is allowed to capture you, put you in like a cage, and have others come through for entertainment or conservation to look at you in this cage, right? And so that's what personhood is supposed to be there, even if it was educational for the whole world, even if we stopped the pandemic by doing this to one human person. That's not supposed to matter in a deontological rights-based system where the legal personhood is supposed to stop that instrumental treatment. Okay, so I wanted beingness to be that type of full stop as well, where any entity that is allowed to be a legal being, is perceived to be a legal being, is not subject to instrumentalization by humans or corporations. And so it's for that reason, that I say a lot of other non-human entities aren't going to qualify for this, because humans and animals use them, right? So it's not really the animal use, it's really the human use. For example, humans eat plants, right? And I can't see a way around that right now. And so that's why I say, even though plants ontologically can also be classified. Good arguments, I think, to classify them as embodied beings, as relational beings, and then vulnerable, just like animals are. The fact that we do instrumentalize them and continue to need to do so doesn't make them a good candidate for beingness, because I do want beingness to be a full stop against instrumentalization and commodification. So in terms of the other entities Jesse mentioned, then it just would be like the non-human entities which we wouldn't approach in that way.
Okay, great. So, I think that helps to answer a question that has come in here about, we talked at the outset about, is this just personhood by another name? And then I had a question coming in about, all right, so if human beings, if the category of personhood persists, and then we also have this category of beingness, is there some inevitability that beingness is going to be seen as at least lesser than personhood as long as these two statuses exist? So I think some of what you've said connects to that, but I want to give you a chance to respond directly. Is this always going to be seen by some as personhood minus?
Yeah, no. So another really great question. It might be, and maybe that will actually give it some more traction, because if that perception just resides at the level of the symbolic and doesn't have a material effect, that might be okay, because the task is to persuade humans, most of whom are kind of immersed in anthropocentric cultural formation, that animals deserve a different status. And this is where, asking a judge to call an animal a being and saying this is what it means rather than a person actually might be more viable, because it might, subsist inside that judge's head, let's say, with a comfort level of saying, well, humans at least are different and are persons, even though, I don't mean it to be an inferior status. It might just have that second best register. But it could be, I've also received the question, well, the critique you're making about beingness, couldn't that be applied to the way personhood functions for humans today? And yes, indeed it could, right? So maybe there could just be another way of classifying, even who humans are, or, trying to make more of a dent in that rationalist version of personhood that is so influential, and such that the personhood term becomes demoted. So it is, I'm reminded also in early days of one of my colleagues, Gillian Calder here at the University of Victoria, who kind of raised a question about, marriage, that in terms of the same-sex debates around marriage, like marriage and this idea of like co-partnership, isn't that always just going to be seen as a lesser status if we don't call it marriage, right?
Skim milk marriage, as Ruth Bader Ginsburg called it, yes. Ironically for our purposes.
For our purposes, yes. So, so it might, but at the end of the day, like given all the, if you really accept kind of what's wrong with the marriage moniker and the concept of marriage from critical discourse, it might be that that term should go away and this term will kind of rise up. So yeah, beingness is susceptible to being seen as less than, but that might give it more traction in certain spaces. The main concern is that it's not diluted to be a legal welfareist concept, right? So as Jess, your wonderful scholarship has shown, that we have non-property classifications for animals in certain constitutions around the world, right? Talking about animals as other than property, and we can see it in some instances right here in Canada. But then when you unveil that legal system, you see, well, animals are still like being held captive in the factory farms and otherwise, but yet the constitution in this country is talking about animals have dignity. So how do these two things coexist, right? Or animals are sentient beings worthy of respect, yet they're still sitting there in the factory farm. And and then we understand that when these terms come to the moment of legal contest, i.e. interpretation, they are diluted down or they're read through an anthropocentric lens. So dignity is vague enough to mean whatever we want it to mean, basically, which, then can accommodate the property system that is there. And so I don't want that to happen to beingness. And so hence kind of the exclusion of other non-humans that are conceptually amenable to the idea, but we would still be instrumentalizing, because I really want animals to have that full stop that personhood is supposed to connote.
Great, thank you. So I have not so far been naming our questioners, but we do have a question that has come in from our shared mentor, Jenny Nadelsky, is listening. So I'm going to read her question, and I'm also going to, Maneesha, send it to you in the chat so that you can see the words without trying to find it in the Q&A. So Professor Nadelsky says that she has been thinking about building into the legal meaning of property and to land a responsibility to care for the land. The hope would be that this would become part of a deep transformation in people's experience of their relationship to land as one of mutual care. I wonder if you think that the language of beingness is broad enough to cover land, plants, insects, water, all the dimensions of the earth community. The concern is beingness becomes another form of exclusion. Mutual care does not, I think, rely on beingness. So this is, I think this connects with some of Professor Nadelsky's work on sort of rehabilitating rights from its exclusionary roots to think in more relational terms, but also kind of layering on this concern that perhaps this approach of putting things that we use in a separate category as maybe, as Professor Nadelsky says, creating just another form of exclusion. So I wanted to invite you to respond to that suggestion. And thank you, Professor Nadelsky.
Yes, thank you, Professor Nadelsky. So great to have you here and have your question. Yeah, it is a hierarchy. But I want to be transparent that it is, right? If we are eating plants, for example, or we are, kind of putting our human purposes onto the land, right? Or using a body of water for our purposes, that's a form of instrumentalization that I don't want to gloss over and suggest is not a form of instrumentalization, which I think is something we might, like to do in many instances. So that's why I want beingness to be reserved for that situation where we're not instrumentalizing. As I tried to say in the book, perhaps it's not coming across properly, but what I wanted to say in the book in that chapter was that doesn't mean that we have to see those of us that qualify as legal persons or legal beings as above these other entities. So I don't think we have to socially rank. And it also doesn't preclude, in my view, an ethos, like an ethic of care or otherwise towards those entities, or to say that there's no responsibility to care. So I very much do think there should be a responsibility to care, but whether or not that responsibility to care triggers the beingness as a subjectivity status in law, I think is a separate question, which I've answered as in the negative for the reasons I've said. So we need a much more robust way to be responsive to land, to water, to plants. And through a care ethic is something that resonates with me as well, and a responsibility ethic. So I don't think the beingness system precludes that. But yeah, I do agree that when just some entities are seen to be beings and others are not, then yes, it is a form of exclusion. But I don't want to suggest it's not. And I hope I've said why I live with that form of exclusion, because I do want beingness to be a full stop against instrumentalization.
So I notice here that Professor Nadelsky has added one can move from an extractive relationship to the earth to one of mutual care, even if all of Earth's life forms live off one another. So I think this is a really interesting point, and I want to invite you to maybe offer some nuance on this idea of exploitation or instrumentalization. Is there a difference in the way that that human beings have been instrumentalizing animals, and the kinds of instrumentalization that will maybe persist vis-a-vis non-beings in this framework that you've developed? So is it not, in a sense, the case that just as we're all vulnerable, we are all also using one another at all times, that life feeds off other life, and that maybe it's hard to conceive of as hard of a stop or dividing line, as you're suggesting, between things that are exploited and things that are not. Does that suggestion trouble you, or do you have a response that you would like to give for that?
Yes, I do think, right, yes, we are in deeply relational networks, right? And we are using each other in different ways. But there are limits on that, right, type of use. And my concern is that that we may be too quick, like vis-a-vis animals, to suggest it's a relationship of mutual care, and even other non-humans, because who is suggesting that? We are, as humans, right, with all our human projections. And where is the voice of whoever is in that equation of what is in the relationship of care? How can that voice be articulated in a way that is not just from the kind of a human mindset, as deeply mindful as that mindset might be, and respectful and responsible and extremely well intentioned? So I do think that we have a responsibility to recognize that authorial imprint when we say it's a mutual relationship of sustainability. And the material impact might be just to always keep that in our mind as kind of, the feminist response care ethics that I draw upon in the work ask us to do when we're like responding to the other. So again, coming back to beingness, I do want beingness to be a subjectivity where we don't assume like that, we don't legally authorize that type of use of another legal being, right? And just say this is a mutual interdependence. I think we really need to say, well, for some, we really, just like we would, like, for Jenny, as you've written in your work, in the family context, there's lots of mutual interdependence and love and care going back and forth. At the same time, we need some hard stops on some of that if that's what like a particular family member wants, right? So the same idea would be available for those classified as legal.
That's really helpful. Thank you for that. So I want to take some time to talk about some specific animals. I think we've been talking in a fairly abstract way about animals' position in the legal order, and I noted that when we were together recently on the keynote panel for the North American Animal Law Conference, you mentioned that dairy cows were in the front of your mind as you wrote this book. And so I want you to say a little bit more about how dairy cows inspired this work and how that specific use context maybe informed some parts of your theory. But I want to also layer onto that some questions that have been coming through in the Q&A. I've had a few people asking about where wild animals fit in this theory. So I would like to invite you to tell us a little bit about the dairy cows that were front of mind, and whether or not your approach, despite maybe having thought about dairy cows more centrally during the writing process, if there's a place for wild animals in your thinking and how that would operate.
Okay, yes. Thank you, Jess. And for the questions from everyone. So yeah, I finished this book in the in between moments and the during moments of nursing my little one, an experience I had for the first time as a human mammalian mother. And, I have been kind of thinking about animals for a long time, right, since I was really in high school, and then writing papers and, hopefully thinking deeply critically about these issues for a long time. But it wasn't until I had my own nursing experience, lactating experience with my child, that I felt like I could understand a bit more the harms of the dairy industry. And I'm even getting a bit emotional talking about it. It was just this profound connection. And then if you think, if we know anything about the dairy industry, and of course, Jess's work is so illuminating for us, as are other feminist scholars, uh, there are a multitude of harms, right? But a very significant one is, how do we get why are humans drinking another mammal's milk? Where does that milk come from? Even the most thoughtful people don't understand that that cow was pregnant and there was a baby that came out, and that baby is being denied very early on being with their mother. And they're going to their own death, or that they're going to their own immersion in a reproductive mechanic system. And if other harms include the not just loss right after a long period of gestation to lose your child, but then to have your milk taken by others for not your child, right? And to have that done against your will, and then to go back into a system of forced breeding to do that all again multiple years. So in many parts of the book, I kind of reference these cows because it was just so personally relevant to my situation at the time as an author when I was writing this. And I feel that even within the, at least North American animal movement, we don't spend that much time talking about dairy as a kind of represented part of the whole of all the horrors that animals experience. And my feminist background inclines me to think that's because it is a feminized issue, and it has to do with like feminine reproductive body parts and so on. So that also explains kind of the feminist theoretical grounding of the work. But that's why the dairy cows were so kind of formative. And after writing this book, which is very much about legal status and subjectivity, I really did want to then go more deeply into animal agriculture and think more. And Jess, your workshop and invitations have allowed me to do that, to think more about the dairy industry, which I think we all need to think more about. And so, yes.
Did you want to say a word on wild animals? Sorry, I gave you a two-part question. That's always difficult. But so the dairy cows were front of mind, and I obviously think reasonably so. That's a research interest of mine. But so where does this leave wild animals in your theoretical approach that came out of this this research?
Yeah. So yes, the kind of focus of this book, of beingness as a legal subjectivity, of getting animals out of the property status, was to make a deep intervention as to why the animal use industries that are normative in Canada and growing apace around the world, if not already deeply entrenched, are wrong and have to stop. And it's primarily about relationship between kind of colonial legal orders and capitalism, and seeing animals as resources and what's wrong with that. The argument, and I think I've said it, if I recall correctly, in a footnote somewhere, there's a rich literature about what to do about animals' relationships with each other, and should humans be intervening in that. And I just, I have my ideas about that, but it is, so the one thing I can say is the beingness model is not meant to kind of stop carnivores from being carnivores, let's say. But at the same time, it's also not just to, in that scholarship, say we humans owe nothing to wild animals either, right? Especially those are ones that are being preyed upon by the other animals. So this beingness model is really about trying to get humans and corporations to change, and in dominant cultures to change our kind of corporate normative positions about which industries are benign, which industries are boons for society, are helpful, should keep on going, and think more creatively and critically about what we need to phase out and start anew in terms of these massive global industries. So wild animals presumptively would be beings, but that wouldn't affect, I'd have to think separately, and I haven't done that, about what that would mean for other wild animals that are in that relationship with them, let's say in a forest or a jungle. But just a short answer is that beingness is not meant to really interfere with that relationship.
Okay, great. Thank you. So I want to take a moment to connect your work to scholarship and efforts at the revitalization of Indigenous legal orders across Canada and across the world. So I know that you wrote this work on unceded Coast Salish territory in the context of a university where Indigenous law revitalization has been a huge part of the academic project and educational project of the institution. And I've got a number of questions coming in the question and answer as well about what the relationship is between this project that you have developed and Indigenous legal orders that have a very different conception of animals and personhood than that which you are critiquing in liberal legalism. And I wanted to give you an opportunity to speak to that. And at the risk of giving another two-part question, there was one of the questions in the chat specifically connected this question to the perceived conflict between animal rights activism and Indigenous hunting rights that we see emerging in many contexts within Canada and in other nations. So we don't worry about the two-parter. I'll remember to come back around to ask you that once you've finished setting out how you have seen the relationship between Indigenous law and the proposal that you have put forward here.
Okay, yes, thank you again for the questions. So just going back to my previous answer, in the primary intervention and focus of the book is to persuade others as to why the commercial use of animals is something we need to rethink and stop. And that what form does the commercial use of animals take these vast industries in so many areas of our lives? Like, this is how we need to transition away. And of course, there's so many other reasons to do this, environmental reasons, right? But the book is focusing on kind of who animals are and kind of what they're worth is type of reasons. That kind of goal, of course, I think, speaking generally, which is, how I can speak about this at this moment, if we understand Indigenous legal orders in what we know as Canada, and we take that as a sample set, if we understand that they demonstrate a valuation of animals that is radically different from this kind of, corporate Canadian law vision of animals as just resources to be instrumentalized, really is not even like living, as kind of already just deaded objects to kind of go to make our lives, function according to consumer choice, then it is the project that I see as aligned very much with kind of conceptualizations within Indigenous legal orders of animals. So there is another way to say that I do see a lot of overlap between the idea of beingness and the use of animals in many Indigenous legal orders. I mean, there's certainly evidence and lots of scholarship about how Indigenous legal orders worldviews ontologize animals as persons, a different version of persons, but persons as kin, as, you know, with their own nations, animals being governing of their own nations, on par with equal status. And this is, of course, dramatically different from the Western epistemologies, the dominant ones from Enlightenment onward, that really have shaped our common law view, and civil law view as animals of property. And I think it's also important to know, right, like the project of beingness is trying to take away the stain of animality. It's trying to say, why do we think of animals as inferior? Why do we see animalization as a bringing down? And we can look again to indigenous legal orders that actually embed a very affirmative view of animals, as kin, or claiming a kinship with them, or worship or exaltation, as teachers, educators, right, models for human life. So, you know, fundamentally, animals aren't seen in a pejorative, dismissive, inferior way. And so I really do see that overlap, you know, which would lead me to argue that beingness as an intervention is very much like a decolonizing type of gesture or move, given how constitutive a negative view of animals is to colonial legal systems, right? And just how prominent human exceptionalism is in colonial legal orders like the common law. And of course, we know, Jess, through your work and the work of others, how constitutive something like animal agriculture was to the whole colonial enterprise in settler colonies like Canada. So in a way, you know, it's possible to read beingness, although I don't, you know, discuss this in the book, but you know, what I'm saying about how we need to think about animals is an extension of the whole project of indigenizing Canada, right? Because we are trying to revalue animals. And to the extent this is done in many Indigenous legal orders, of course, I don't want to, you know, generalize and homogenize, but I think we can see that trend, and Indigenous scholars themselves say that is a feature. So we can definitely see the overlap. But just if I can take on the second question.
Yes, please do.
But of course, as I've discussed in other work, right, that we often have a conflictual framing instead between kind of what's categorized as animal rights and Indigenous rights. And, you know, a recent article I wrote called Veganism, Dairy, and Decolonization really tries to kind of address this conflictual framing and unsettle it through kind of a focus on dairy. So I don't want to suggest, but what I want to say here is that beingness is not, you know, coterminous with Indigenous legal orders, because I think as much as this conflictual framing is overdetermined, that there will be points of conflict, right? And so to the extent that, for example, hunting, fishing rights, trapping rights are seen as central to Indigenous legal orders, we can see that conflict like very clear. So this is one of the reasons that in the theoretical grounding for the book reflects not just my own academic formation as a feminist post-colonial scholar, but, you know, I did make a deliberate choice to kind of ground the argument in feminist kind of theories of care as expressed in the animal world in terms of the feminist animal care tradition, also called ecofeminism by some, or vegetarian vegan ecofeminism, because while they take a relational view, as many Indigenous legal orders do, it's not an ontology that immediately sees animals as available as edible or as food. So, you know, we can certainly understand the historic needs-based reasons that we have cultural ontologies, scaffolding Indigenous legal orders where interdependence and reciprocity rationalize the killing of animals, right? Or we have kind of cultural narratives that emphasize animals sacrificing their lives or consenting to death so that humans may live. And I'm not suggesting, I don't want to suggest that these are instrumentalizations of animals that are commensurable like with a resource use of view of animals that is kind of endemic to animal use industries. But then like beingness, being at it, you know, kind of grounded in ecofeminist scholarship, this literature, at least some voices, have troubled that narrative. And I think Claire Jean Kim's recent work, looking at different types of contests involving kind of race and animality and indigeneity, would suggest that we have to see that there are, all of us in all our cultures have kind of ways of understanding our world and attributing meaning, as she puts it. And we are suggesting a relationship with animals for specific reasons that could be vastly different in indigenous legal orders from Western, kind of dominant Western views of seeing animals. But at the end of the day, are still a human projection about animals, right? And so the beingness model, it's meant to be a critique of, dominant Western societies and colonial legal orders. But if it was like ever invited to be, interposed into indigenous legal order discussions, would it would have a different stop point than killing animals, even if it's kind of understood to be a consent narrative, because it would trouble that idea of consent.
Great, thank you. And I would also suggest, for people who are just joining us today but haven't been listening to the rest of this series, I think that was a really helpful answer. But these kind of questions, it's always productive to kind of move deeply into thinking about specific Indigenous legal orders. And in this series, we've already seen coverage of Plains Cree conceptions of jurisdiction, Haida conceptions of personhood, and Innu conceptions of personhood. And I would encourage people who've not viewed the earlier discussions within this series to go back and take a look at those and reflect on the place of animals within these various legal orders. So I want to take a moment here to ask you about a question that was very much on my mind. And I will say I am taking my moderator's privilege because there are other questions in the Q&A, and I am bumping myself ahead because there's something I very much want to ask you before our time runs out. So I was really interested in reading your work to see that you make a point of saying that the basic structure of the Canadian colonial state can keep going as it is, while beingness can be layered onto it. So we don't need, for example, a constitutional amendment. The sort of basic structure of Canada's state can continue, including the sort of mixed market capitalist system that Canada operates in. So I wondered if these things were kept because you saw them as sort of productive, useful features of a legal order that could be protective of animals, or if these were sort of compromises because you think these things can't change. So we've got to kind of figure out what we can do within that framework.
Yes, Jazz. It was more the latter. More the latter. So I think that was your intuition, right? And it was accurate. But I do think colonialism, capital accumulation, anthropocentrism are deeply connected. It's so difficult to imagine capitalism without using animals. At the same time, I don't want to take on everything, and I don't want to project an argument to everyone saying we have to change everything before there can be any type of meaningful change for animals. And I do think, like just the way we've seen with COVID responses, you can have a transformative shift. And so if we did want to stop intensive farming, for example, like even less than a year, that could be done, right? And we even see some legislation coming forward. If we did want to tax certain consumptive choices around animal-based products, as we do other consumer items, that can be done. If we want to tax them very heavily so that they become, and if we want to stop the subsidies to the agricultural industries, the animal base, that can be done now, right? And all of a sudden, these consumer capitalist choices will look very different in terms of what is available and what we immediately reach for at the grocery store, or what we don't in our day-to-day lives. So same thing with the constitutional element. I do think we can have those types of legislative reforms can be done without waiting for a constitutional kind of embracing of animals, or even like an interpretation of our charter jurisprudence that's multi-species. There are things we can do within the current system. Just the way that we've had, some measure of progress. I don't want to suggest a linearity, but on human rights issues within this system, right? So do we need a wider transformation? Yeah, I would agree with those that we say we do, definitely. but if there's a political will, right, and if there's the collective will, like the public will that convinces the politicians or convinces, even courts to take on something and change it, we can do that now.
Wonderful. Thank you. As a final question, for those of us who've been won over by your fascinating work, and I certainly count myself among that group, I was hoping you could say a little bit about what's coming next for you. What forthcoming work can we look forward to building on what you've set out here today?
Yes, thank you for that question, Jess. So I'm hoping for a next monograph. So I have a Social Science and Humanities Research Council funded project on the rule of law and animal vulnerability in animal agriculture. So this is a project that is thinking about, here we have this ubiquitous concept, not just in legal circles, but outside of the rule of law. And it's a colonial concept, but yet it's with us very deeply. And others have suggested it can be rehabilitated into something else. So I want to think about, I've suggested personhood can't, but I want to now think about the rule of law and how can we think of a much thicker conception than the one we normally have, like in countries of the global north, to think about basically government abdication of responsibility to regulate. So if you think of Canada as a highly regulated society, right? And when I teach administrative law to students, I say we are a highly regulated society, but here's one area that we hardly regulate in. And I give them the example, right, of the food systems involving animals. And so for the animals' benefit, right, other than, let's say, human food safety and all of this. And so can we think of that regulatory landscape as some type of rule of law violation? And can we think of this, just as your work has shown, like the implicit supports that go into the system as a rule of law violation when you basically have industry kind of self-governance as the norm? So that's one project. And another project involves human children. So kind of, going back to my own experience becoming a mammalian mother, and just really seeing firsthand how much, it as you grow up yourself, right? And we know it from just our general awareness of advertising and what's around us in the libraries and pitched at children. But now just seeing how immersed children are in the world of animals and how everything, that is directed at them has some animal component of relating. How is it, for example, then in a dominant Western culture, the adulting process takes them out of this and into kind of the norms of what is proper human performance vis-a-vis animals, i.e. to eat them and to eat a lot of them and see them as properly in cages and go to petting zoos and all of this stuff. So I want to think about what are our legal responsibilities to human children in relation to kind of how we enculturate them into a human position of dominance vis-a-vis animals.
Well, that sounds incredibly interesting, and I cannot wait to read this work. As somebody who tries to read everything you write, Professor Deckha, you don't make it easy given how prolific you are, but it is always a delightful challenge because your work is always so enlivening, always brings a new angle and a thoroughly theorized and really heartfelt approach to a subject area that I think increasing numbers of people are seeing the importance of as a material social problem and as a challenge for legal theory more broadly. So I'm so grateful for the opportunity to talk to you about this book and your work more generally today. I feel that I've learned a lot, as I always do, from our conversations. And I'm so thankful to all of you who have been placing your questions in the chat. It has been great to have this kind of engagement as well from other readers and listeners of Professor Deckha's work. So I think Pat Paradis wanted to say some final words, so I'll welcome you back and thank you so much, Professor Deckha, for joining us, and thanks to all of our audience members for joining us in this conversation.
Yes, thank you.
Well, yes, I did want to thank you both very, very much. I mean, wow, it was a tremendously interesting discussion. Jess, your questions really just dove us into the pith and substance and the heart of Maneesha's work and thinking. And Maneesha, you've certainly exposed the deeply entrenched ways in which we think about animals, and you've given us an entirely new way of thinking about them. I mean, this concept of beingness, I think, honestly, transformative seems a bit of an understatement. And so there, you've given us lots to think about. Thank you both very, very much. I want to also to thank Zara Ahmed, our administrator for the center, and Alina Rietsma, the center's public legal education coordinator, for their work in preparing, advertising, and running this webinar. We also want to mention the Edmonton Public Library because, and thank them for posting our event on their events listings. I think this is going to really expand the reach of what the center does, or in terms of getting out to the general public with our events. So thank you very much. And as Jess said, last but not least, thank you very much to our audience members for your interest and participation. I mean, the questions were really, really interesting. You will be getting a link to a short feedback form following this webinar, and we would very much appreciate it if you take the time to fill it in. We truly value your feedback, and it does inform the many choices that we have to make with respect to the work that we do. The webinar is being recorded and will be available early next week on the center's website. Thank you very much.